Very good evening, Shivangi. Please confirm about the voice and the video. Any volunteer, please confirm about the voice and the video. Very good evening, Shivangi. Mamta, very good evening. Okay, thank you, Shivangi and Ayush, for clarifying that. On that note, let's begin with this class. Okay, ji. Thank you very much. So, first of all, I welcome each one of you to my class on the mock test of criminal law. Let's start with my brief introduction first. In case if you don't know my name, it's Sandeep Khatri, and these are my areas of specialization: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. I have also shared the link of my profile on Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask questions related to your judicial preparation. And at last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now coming to this class, so I request you everyone, please be attentive, and this is going to be interactive session. So make sure if you are not clear with anything, feel free to ask your questions in the comments. Now coming to the MCQs, today we are going to solve 20 questions on IPC, 10 questions on Indian Evidence Act, and the rest 10 questions are on CrPC. So this is basically the division of the questions. Chaliye, perfect. Now coming to the first question. Before that, a humble request, students, before writing your answer, whatever it is, A, B, C or D, please make sure you mention the question number, like numeric 1, and then whatever your answer is, A, B, C or D. Here is the first question. Infancy is an absolute exception has been provided under section dash of IPC. Choose the most appropriate one. Ayush, the current affairs session will take place only on the Saturdays. Okay, so the upcoming Saturday basically. Top 3 students to answer correctly: Shivangi, Ladley, and Ladley, you have answered incorrect. So Shivangi, Ayush, and Suman, top 3 students to answer correctly. So student, here B is the correct answer. That is section number 82. Why not D? Because infancy, when it comes to the concept of infancy, it is mentioned under section 82 and 83. But the question was about absolute. This is the keyword that you need to focus on. And because of this, the answer is section 82. Done. Next. Which of the following sections have been inserted in IPC 1860 by the Criminal Law Amendment Act 2013, namely? Choose the most appropriate one. Top 3 students to answer correctly. First one, Mohit, followed by Sunita and Ladley. Yes, everyone's answer is correct. That is D. Okay, there are some other questions as well important to this one. Students, I hope you do remember which committee brings Criminal Amendment Act 2013. So you should know the name of the committee as well. Anyone who can write the name of the committee in the comments? Justice J.S. Verma. Correct. And this was because of Nirbhaya rape case. And now after that, we do have also Criminal Law Amendment Act 2018 amendment as well. Okay, we do have Criminal Amendment 2018 as well. So make sure you know the important sections of that as well. To establish section 34 of IPC, starting from Neetu, Mohit, and Sunita. Everyone has answered correct. Yes. A is the correct answer. That is common intention. That needs to be proved. So basically, common intention is one of the essential of section 34. Student, I have one more question attached to this. Is there any difference? Listen the question carefully. Is there any difference between same intention and similar intention? Anyone who likes to answer in the comments. Is there any difference between same or similar intention? Okay, Sunita, what's that difference? Because you are answering yes. Prem, yes. Ayush, big difference. My God. Mohit, Mehboob Shah versus Emperor. Yes, yes, yes. You know, I have told you, listen the question carefully. My question was, is there any difference between same or similar intention? Same or similar, not same or common intention. I'm not asking about same and common intention. You are answering about same and common intention, by the way. Mehboob Shah versus Emperor. My question is same or similar. Now please answer. Okay, now everyone is answering no. Okay. Okay, perfect. Yes, the answer is correct. There is no difference between same or similar intention, but yes, when it comes to same and common intention, there is a that's completely a different concept. Okay. Now I have a last question in association with this. Can you recall any section number for same intention? Can you recall any section where the concept of same intention has been incurred? Very good evening, Virendra and everyone, those of you who have just joined. 149, no. No. 149 is about common object. I'm asking about same intention. Yes, Shivan. Okay, Mohit, first one to answer correctly, followed by Shivangi. Section number 35. Okay, section number 35 is the correct answer. Okay. Okay, Siddhi Agarwal, you have asked why. So let me answer this question. You have answered 149. 149 is about common object. Section 34 is about common intention. Section 35 is about same intention. I hope I am clear with this. And still, if you have any question, please do mark at the end. Once we are done with all the questions, you may ask your questions. Okay, ji? Moving forward. Next. Very good evening, Kusum. Section 34 of IPC. Choose the most appropriate option. Mohit, Sunita, and Ayush. Top 3 students to answer correctly. And yes, everyone's answer is correct. That is B. Section 34 is a rule of evidence. Please, students, mark this. This is one of the most repetitive question, that section 34 is not does not create any substantive offense. Okay. Section 34. Okay, let me ask this to you only. Why I'm answering. Okay. if you need to give only a word or a sentence, ki what is, so suppose if in interview someone is asking to you, what is section 34? What is going to be your answer? What is section 34? And you need to answer only in the, one or two words or in a one sentence. Yes, please. Answer in the comments. I'm just assuming I know this very well that each one of you know what section 34 is. Okay, but you have never answered this question. What is section 34? So what is that key word which is section 34? Anyone? Okay, this is something which I was expecting. Mohit and Shivangi both have answered common intention. Now my counter question to each one of you, Mohit, Shivangi and Suman, section 34 define common intention? The answer is no. So how can you say it's a common intention? No. Common intention is just one of the important essential of section 34, but section 34 is not common intention, by the way. Okay? Come on, I can expect at least one correct answer. Ladley, I have not understood what you have written. Sakaria Bhagidari. Okay, this must be some Hindi term. Sakariya Bhagidari. But I hope this is just the term for common intention. Now I have got the correct answer. Yes. Sunita and Shivangi. The correct answer is joint liability, students. Section 34 is all about joint liability. Okay. So joint liability is the correct word. Okay. Now please do remember that for the rest of your life. Moving forward to the next question. Easy one. The term voluntarily has been defined as an effect caused by means whereby a person intend to cause it or by means at the time of employing those means know or had reason to believe to likely to cause it under. So direct question. Section number of the term voluntarily basically. Okay, starting from Mohit, everyone is answering correct. Shivangi and Ayush. Yes, everyone's answer is correct. That is A. Section number 39. Okay, can anyone tell me what is the difference between intention or knowledge? Please do write in the comments. What is the difference between intention and knowledge? Or they are the same? You can answer this as well. If you think that these terms are synonymous, or if there is a difference, please tell me the difference. You may answer with the help of a definition or with the help of an example, as you wish. Okay, Neetu is saying not same. Okay. So same to nahi hai. So in short, there is a difference. Now the question is, what is the difference between knowledge and intention? And these are one of those two terms which are going to come come repeatedly in front of you when you are studying IPC. Okay, let me answer this. Okay, see, let me make it a very simple for you. Intention means desire of the mind. Knowledge means awareness of the fact. So let's assume there is a gun in my hand. I do have the knowledge. I do know this fact that if I shoot someone, if I aim and I shoot someone, that the person will die. That's the knowledge. Now intention, I really want to kill someone. That's the intention, the desire of my mind. So that is the difference. Next, under section 45 of IPC, life denotes Top 3 students to answer correctly, Mohit, Ledley and Ayush. Yes, everyone's answer is correct. That is D. Yes, the answer is correct. If you are going to read section 45, that says that life means life of a human being. So basically, when it comes to death as well, so death means death of a human being. So why this is important? Now the question is, suppose if there is a Mr. A and he killed a tiger, can you say that the Mr. A has committed culpable homicide or the murder in that case? Yes, please do answer in the comments. If Mr. A killed a tiger, can we say Mr. A has committed culpable homicide or murder? Yes or no? Mohit has said no offense. No, never. No offense. Okay, by the way, I think no offense is not the correct answer, as this may fall under any of the special laws, because even animals do have the right. But yes, you can say it can never be the case of culpable homicide or murder, because the death that has been used in section 299 and 300, that is specifically for human beings, not for animals, right? And let's suppose if we, okay, let's make it more interesting, by the way. Okay, what if a tiger kills a man? Now you tell me, can there be a case of culpable homicide or murder? Yes, please. If a tiger killed a man, Mr. A, tiger killed Mr. A. Now, tiger will be liable under culpable homicide or murder. Please do answer in the comments. See, I'm trying my level best to, make it as interesting as I can. Okay, so I need your answers now, please. And mind it, it's not about right or wrong. It's about what do you think, so I can correct you, right? Okay, starting from Sunita, everyone is writing no. No humans are to be involved in killing. Okay, no murder or culpable homicide. There are no any offense regarding tiger. See, the answer is going to be that would not constitute crime. Why? Because do you remember the essentials of crime? The very first essential of the crime that you read, the first one is person, right? And person includes human being, or you can say section 11 of IPC. So if we go by that term, so the person does not include animals. So this will not be a case of crime. Okay. And absolutely no case of culpable homicide or murder if a tiger killed a person. I hope it's clear to everyone. Okay. Ayush, mens rea of tiger. No, we are not going to, we are not going to, run a trial for a tiger because of obvious reasons, right? Next. Next one. How many types of punishments have been prescribed under IPC? Very good evening, Tariq Khan and everyone, those of you who have just joined. Okay, starting from Mohit, I guess everyone has answered correctly. Yes, C is the correct answer, and that is total 5 punishment. Originally, when it comes to originally, if someone asks how many types of punishment under IPC, originally if I am asking, then the answer is going to be 6 punishments. But now, currently, we have only 5 punishments. And if we want to name them, the first one, the capital punishment, that is death. The second one is imprisonment for life. Then simple imprisonment or rigorous imprisonment. Then it's your fine, and then the forfeiture of property. Next. In case of an offense punishable with fine only, imprisonment for non-payment of fine. See, when it comes to the punishments part, in IPC, there is a certain language that has been used repeatedly. and that is imprisonment of either description, which may extend to, right? So imprisonment of either description. When we say either description, it may be simple or it may be rigorous. But when it comes to in case of offense punishable with fine only, then what is going to be the answer? Ayush, the question you are asking about is, can there be a case of negligence or not? That may be, depending upon certain facts. Okay, if someone has done negligence on their part. Starting from Tariq Khan, everyone has answered correctly. B, B, B. Mohit, you have answered C. No, Mohit, the correct answer here is B. Okay, so it needs to be simple only. Under section 498A, one of the most important section from IPC, 498A, which is usually in the news as well. And yes, this is one of those sections. And the term which I'm using is, but from the Honorable Supreme Court has said this, that 498A has been misused in our society. So now coming to the question, under section 498A of IPC, cruelty includes. Please do answer. Top 3 students to answer correctly, Shivangi, followed by Mamta and Ladley. Yes, A is the correct answer. See, students, when it comes to cruelty, okay, there is one interesting story as well in relation to this concept. If you are going to go in the history of this term cruelty, you will find that cruelty usually means, in the history I'm talking about, physical cruelty only. Okay, but with the time we do understand that yes, there can be a case of mental cruelty as well. Okay, so it's not all about physical. It's about when someone is taunting you on a daily basis that you are not good for anything, you're just wasting our money, you're wasting our life. If someone is passing these statements, or in relation to this question, if a husband is passing a statement to his wife on a daily basis that you are not beautiful, you have not come up with good amount of dowry, I was dreaming about the big car, but you have not got me that. So if husband is passing these kind of statements on daily basis, that husband is actually causing mental cruelty to the wife. And the thing with this question is physical cruelty only, that's why B is not the correct answer. Mental cruelty only, that's why this is not the correct. And A is the most appropriate answer, that is harassment of the woman. Next. Section 73 of IPC provides for the maximum limit of solitary confinement to be. Okay, I do have some interesting question in relation to this topic as well. So let's first check your answer from this question. Starting from Sunita, everyone has answered C, that is of 3 months, which is the correct answer. Now you tell me, when it comes to IPC only, are there any exceptions, and can we extend this 3 months period of solitary confinement? Under IPC only I'm talking about. Are there any exceptions when we can extend this limit of 3 months? Anyone who likes to answer. Are there any exceptions? Yes or no? In the IPC only I'm talking about. Okay, Tariq Khan have answered till now. Okay, Ayush no, Suman no. Okay, everyone is answering no, and that is the correct answer, students. There are no exceptions. The maximum limit is of 3 months. Okay, so please do remember that. Okay, there can be certain exceptions in some special laws. Okay, but not in the IPC. Okay. Not maybe, there are exceptions in special laws, by the way. Okay, like I can give you some examples as well. For example, this like suppose in the cases like Ajmal Kasab, right? But obviously they are held in some TADA or some special laws. So for them it will be applicable. Done. Nothing is said to be done or believed to be done in good faith, which is done or believed without due care and attention, is the definition of good faith contained in easiest question you can ever dream of. Good faith defined under section basically. Tariq, how can you answer D? 52A. 52A is Arbor. Mohit, Ladley, and Monica. And yes. Mamta, it's not D. Okay, let me give you this my personal observation as well. I don't know how, I don't know why. But yes, I do have got this answer from, good amount of students have answered that, 52A is good faith. I don't know how this, through which calculations you have done this mistake, but please make sure you correct that. Okay, section 52 deals with good faith. 52A is Harbor. Section 76 and 79 provide the general exception of. There is a famous maxim as well in relation to this question, which you should know. Starting from Ladley, everyone has answered B, 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 and that is the correct answer. Done? Yes, mistake of fact. Okay, there cannot be any excuse for the mistake of law, but yes, as far as the fact is concerned, mistake of fact can be excused. So B is the correct answer. Yes, Ayush, MH George is one of the landmark judgment on that. There are many other R versus Tolson as well, and so on. Okay, answer this one. It's kind of an application based question. Starting from Ladley, each one of you have answered A. And here comes the correct answer. Only one student. Okay, second, Sunita, first one to answer correctly, followed by Suman. I told you, do read the illustrations. This is one of the illustrations. This is one of the illustrations of section 378. A has committed the offense of theft. D is the correct answer. Okay. Yeah, you are supposed to, Ayush. That's why. Just because this entrusted has been written, your conclusion was obviously there was a trust and now it's a criminal breach of trust. Okay, let me give you one practical example as well so that you can, remember this illustration for the rest of your life. Now do listen carefully, okay? Now suppose you went to your friend's house, okay? And that your friend offered you a tea. And obviously if he is offering you tea, that is going to be in a cup and plate, right? There is going to be a cup. And the moment your friend went into the kitchen, you run away with that cup. Now the question is, which offense you have committed? Criminal breach of trust or theft? Now obviously your friend only offered you that tea with that cup. But the purpose was so that you can drink easy, so that you can take the tea easily, right? Not you, so you can run away with the cup and tea. And that is why this will amount theft. So I hope now you'll keep remember this illustration. Done? And if you still have any confusion, make sure read the illustration. I don't remember the number of the illustration, but this may be probably fifth or the sixth illustration of theft. Okay. Ayush, that depends upon the cost as well, the cost of the cup and so on. Okay. So not exactly 95. Next one. I have not received the correct answer till now. I have not received the correct answer till now. Okay. Sunita, by the way, what were you waiting for? Now it's C. Yes. Sunita followed by Suman. Correct answer C. It's a case of fraud. Now, can anyone tell me why it's not a case of cheating by personation? Please tell me the reason. Sunita, yes. You have answered correctly. C is the correct answer. But now I want to know the reasons why it is a case of cheating and why not cheating by personation. Sunita, waiting for your reasons, or anyone who wants to attempt. Okay, perfect. Correct answer, Sunita. Now let me give you the reasoning, students. See, cheating by personation is, suppose, let me take my own example. If my name is Sandeep Khatri, right? And if I'm telling you that my name is Shah Rukh Khan, I'm the actual Shah Rukh Khan. So what I'm doing? I'm doing cheating by personation. I'm Sandeep Khatri, but I'm, pretending myself in front of you that I'm the one who is Shah Rukh Khan. So that is cheating by personation. Now coming to this question, A by falsely pretended to be in civil services, which means A is A only. He is pretending to be in civil service. Okay. So he has not changed his personality. Okay. And that is why this would still amount cheating only, not cheating by personation. Okay. Next. Whoever cheats shall be punished with imprisonment of either description for a term which may extend it to. What is the punishment for cheating, by the way? That is what the question is all about. Just a second, I am doing a refresh. Actually, your comments are not showing. Okay, now it's fine. चीटिंग की पनिशमेंट 3 years है? I don't think so. Do I need to cross check? Just a second, I'm doing a cross check. I think it's 1 year only. The answer is 1 year. 417. Nawab Khan, first one to answer correctly. 1. Sara Khan, yes, A is the correct answer. 1 year. A voluntarily burns a valuable security belonging to Z, intending to cause wrongful loss to Z. A has committed. Monica, first one to answer correctly, followed by Padma and Mohit. And everyone's answer, I think, it's correct. Okay, answer this, students. When it comes to the offense of mischief, wrongful gain is an important essential for the offense of mischief. Yes or no? Please do answer this. I'm repeating myself. When it comes to the commission of the offense of mischief, wrongful gain is an important essential for mischief or not? Yes or no? Starting from Ayush, everyone is writing no, 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 no. And that is the correct answer. Okay? Done? Minimum number of person required for the commission of an offense under section 390. कितने लोग चाहिए कम से कम for the commission of offense under section 390? Mohit, you are not attentive. Shivangi, Ladley and Ayush, top 3 students to answer correctly. Monica, be attentive. I'm asking about section 390. What is section 390? Robbery. So to commit robbery, you need minimum 5 persons. No. 2 persons. No. Even 1 person can commit robbery. Yes or no? Robbery can be committed by only 1 person as well. Okay. Students, please do write the question number before your answer. Humble request. वो फिर ना मिक्सअप हो जाता है नहीं तो. Okay, now coming to question number 19. First one to answer correctly, Sunita. I guess, Sunita. Followed by Ladley and Ayush. Yes, C is the correct answer. Padma, please do correct your answer. It's not A. It's C, abatement of an offense. Okay. So C is the correct answer. Anyone can tell me the section number for this one? Section number. The concept which you have applied here. From which section number? The answer is C. $115? No, it's not the case of 115. It's a simple case of 108. Section 108, who is an abater? 108. Okay. Next. Section 91 is the exception of. Okay, I got it, Sunita. Why you have answered that? 115. My question was why he is considered as an abater. So I was expecting 108. An explanation 3, I guess. Section 108, explanation 3. 20. Only student to answer correctly of question number 20 is Mamta. क्या कर रहे हो? 87, 88 and 89. 86 is not the exception of 91. 91 में जो आपकी exception है वो 86 नहीं है. D is the correct answer. None of the above. The correct answer is 87, 88 and 89, which is not mentioned here. Okay. Now from here onwards, you are going to get 10 questions on Indian Evidence Act. Okay. First question on Indian Evidence Act. Evidence may be given in any suit or proceeding of the existence और नॉन एग्जिस्टेंस ऑफ एवरी. ये और होगा, एग्जिस्टेंस और होना चाहिए ना, ऑफ क्यों है? अभी मेरे पास बेरेक भी नहीं है वैसे. Top 3 students to answer correctly: Sunita, Padma and Ledley. Yes, everyone's answer is correct. That is C, both A and B. When shall the witness be cross-examined? Top 3 students to answer correctly: Mohit, Sunita and Suman. No, Suman has answered B. No, sorry Suman, your answer is incorrect. Ledley, yes. A is the correct answer. Okay, I have some questions associated with this concept. Is it mandatory for the adverse party to do cross-examination? Is it mandatory? Not mandatory as such. Correct answer, everyone's no. It is always the choice. ठीक है जी. Next. An admission is a statement. Sunita, Mohit, Ledley, correct answer. Sarah Khan, please do correct your answer. Okay, there is an amendment in admission. Section 17 defines the term admission. So admission may be in oral or documentary or electronic form. So the answer can be, the best answer can be both A or C. Okay ji. One of the most famous section from the Indian Evidence Act: no confession made to a police officer shall be proved as against a person accused of any offense. Mohit, A and B same नहीं थे उसमें. There was a difference. और and का difference था. Okay? That difference was intentional. And in short, that was not a coincidence. Okay, everyone's answer is correct. Mohit, Sunita, and Ayush, C. Correct answer. Students, is there any exception to this section 25? Is there any exception to section 25 when you give confession to police officer and that will be, treated as an evidence? Are there any exceptions? Mohit is answering 27. No, Mohit. 27? क्यों भाई? No. 27 is altogether a different concept. I'm not. See, first understand my question. My question is section 25 says if someone is confessing in front of a police officer, there is no evidentiary value of that confession, right? This is what section 25 is. Now my question is there any exception to section 25? Which means exception, if you are saying yes, there is an exception, it means that if someone is confessing in front of a police officer, that will be treated as an evidence. I hope now it's clear. Now do answer. Are there any exceptions? 26, 27, 26. 26 is, by the way, not in front of a police officer. It is, by the way, when the police officer take that person in front of a magistrate. So the whole situation has been changed. So you cannot say that 26 is the exception. 26 is altogether a different circumstances. When that confession can be relevant if you took that person in the front of magistrate, not to the police officer. Dying declaration. Oh, Sunita and Avantika. अरे क्या बात है. यहाँ तक तो trust me, even I am confessing I was not there. Dying declaration. So basically the thing you are talking about is FIR. Or if that is a dying declaration, even that case. Section 6 or 32.1. That may be. That, okay, let me think that way. But that is going to be dying declaration, not confession. Wait, there is a difference. That would know, like you cannot say that's confession, that's dying declaration. So basically I think the most appropriate answer of that question is going to be there are no such exceptions. Okay? Because the moment you use the term dying declaration, that is no more a confession. Right? Ayush, I just told you the answer that was in my mind. There are no exceptions. Okay? Next. If a confession is made under a promise of secrecy, we are getting spam messages as well, by the way. Am I that famous? Really? Usually that is a sign of a famous educator. But okay. Just ignore that. Yes, focusing on the questions. Starting from first one to answer of question number 25. Mohit, followed by Ladli and Sunita. Okay. Nawab Khan, please do correct your answer. The answer is relevant. Okay. And it's basically section number 29. So Nawab, please do refer section 29. Okay. After the class. Next. Starting from Avantika, everyone is answering A. Okay, no, वो तो 25 का आंसर कर रहे थे. Starting from Sunita. ठीक है, 26. Everyone is answering A. Correct है. An oral account of a copy compared with original. It's a primary evidence, secondary evidence, oral evidence, or no evidence. Come on, I can expect at least one correct answer. B is not the correct answer. B is not the correct answer. Not the correct answer. Not the correct answer. Mohit, oral evidence is not the correct answer. अब तो दो ही और बच गए हैं. And yes, D is the correct answer. No evidence. Now, who can tell me why D is the correct answer? Who can tell me why D is the correct answer? The reason. Nawab Khan, please tell me the reason. Preeti, tell me the reason. Suman, tell me the reason. Because of not in writing. No. Because oral account copy. It was not original. There was a copy involved in that. The oral account that has been given, that is because of the copy of the original. If oral account was of the original, then it will be considered as a secondary evidence. Okay? हाँ, now you got it, Ayush. It was secondary का भी secondary, and secondary का भी secondary is no evidence. Now you have, and this is basically, if you are still not clear with it, this is the last illustration of secondary evidence. Where the question which from where I have picked this is the last illustration of secondary evidence. Okay. Next. (28) Top 3 students to answer correctly: Sunita, followed by Mohit and Sara. Yes. B, Aman is the correct answer. Nawab, please do correct yourself. A is not the correct answer. Aman is the correct answer. Aman is the one who prosecutes Biswa for theft. Okay? And Aman is the one who wishes the court to believe that Biswa admitted the theft to Daman. So, which means if Aman wishes that the court must believe on a particular fact, then the burden of proof is on Aman only. Okay? Section 103 of Indian Evidence Act. This is one of the most repeated question from your exams, by the way. Most repeated question from your exam. First one to answer correctly, Sunita, Ladli and Virendra. Everyone's answer is correct. 106. This is section 114A, presumption as to absence of consent in certain prosecution of for rape. Yes, correct, Nawab, under section 106. Starting from first one to answer correctly, Mohit, followed by Sunita and Kulveer. Preeti, Ladli, please do correct your answer. D is the correct answer. ठीक है जी. The court shall presume. And what shall presume? She did not consent. Now some questions from the CrPC. Arrest by private person and procedure on such arrest. Section 43, C is the correct answer. Yes, quickly, easy answers. These are the most famous sections from the CrPC I'm asking about. 436 is the correct answer. Kulveer, 301 is the correct answer. Mohit, A is the correct answer. Section 301 CrPC. Section 69 CrPC is the correct answer. Sunita, Mohit, and Ladli, top 3 students to answer correctly. First one is true, but second one is false. FIR in itself is not a substantial piece of evidence. So that was it, students. इसके बाद के जो questions हैं वो हम यहीं से continue करेंगे. Criminal law पे I have already taken one class. This was the second class, and tomorrow is going to be the last final class on criminal law MCQs. ठीक है जी. तो इसके आगे के जो क्वेश्चंस हैं हम वो नेक्स्ट क्लास में ही कवर करेंगे. नाउ इट्स टाइम एज वेल. सो नाउ एनीथिंग विच यू आर नॉट क्लियर विद, इफ यू हैव एनी क्वेश्चंस, इफ यू हैव एनी क्वेरीज, you may ask. And I need to share one important information as well. Students, there is a All India Judiciary Scholarship Test where you can win 100% scholarship on your Unacademy subscription. The test is going to be on November 13th, 11 a.m. This is completely free of cost. So make sure enroll yourself as soon as possible. Okay, and there is a chance to win exciting prizes as well. Now, anything which you are not clear with, Preeti, the timing will remain the same. That is 7 p.m. I have already scheduled my schedule for YouTube classes on my Telegram channel as well. You all are welcome. Padma, Mohit, Ladley, Kulveer, CPC I'm taking on Unacademy as well. Right now I'm taking special classes and plus classes on CPC. Okay, on Unacademy app. In special and plus classes. Yes, Kulveer, CPC mock will be also there. But maybe not on YouTube, in my special classes. Chaliye, you all are welcome. So that was it from my end, students. See you in my next class. Till then, yes, it's time to say peace.